case briefs, and so much more. LSData's got what you're looking for.
In the Interest of K.F., a 1989 case heard by the Iowa Supreme Court, a mother with chronic schizophrenia, Karen, appealed to stop the termination of her parental rights for her child, Kristi. The court focused on the idea that if a child has been deemed in need of assistance and custody has been transferred from the parents for at least 12 of the last 18 months, parental rights may be terminated if there is clear and convincing evidence that the child cannot be returned to the custody of the parents. Kristi was placed in out-of-home care due to Karen's illness, and the state had to prove that she could not be safely returned to her mother's custody. Witnesses testified that Karen lacked understanding of her illness and was unlikely to take the prescribed medication or provide adequate care for her daughter. The Court of Appeals initially reversed the judgment of the juvenile court, but ultimately, the court affirmed the decision to terminate Karen's parental rights, emphasizing the child's best interest and future safety. The court overturned the Court of Appeals' decision and upheld the district court's judgment, determining that Karen's delusions and insufficient oversight into her schizophrenia prevented her from adequately caring for Kristi. Witnesses testified that long-term foster care or adoption would provide Kristi with security and stability. The court took into account that mental disability alone is not a sufficient reason for termination, but if it poses a risk for the child's safety, it may be a determining factor in the decision-making process. Ultimately, the court deemed parent-child relationship termination necessary for Kristi's best interests.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.